Joseph sent us an email regarding his concerns surrounding his overseas employment. Last year, Joseph procured a loan from a lending company because he needed to pay his recruitment agency's placement fee in order to get to work to Canada. He was loaned the amount of 220,000 pesos. At that time, after procuring the loan, Joseph was already having second thoughts whether he will still pursue his employment abroad. According to the recruitment agency, he can no longer back out since everything has been arranged and his papers and documents to Canada were ready. While in Canada, Joseph started to worry because the amount loaned to him, which he used to pay his placement fee, has an interest rate of 3.75% per month. Since he was not able to pay for 5 months already, his loan ballooned to 323,000 pesos. Thereafter, someone told Joseph that Canada does not require any placement fees for overseas workers in order to get employed in that country. Joseph's questions are as follows. First, can the lending company sue him for non-payment since he signed a promissory note and issued post-dated checks? 6, can he legally question the rate of interest that he is paying with the lending company? Third, considering that Canada does not require placement fees in order to get employment therein, can he get his money back from the recruitment agency? And fourth, can the lending company have him deported from non-payment or for non-payment of loans? Joseph, remember that all loans must be paid, especially if you cannot show that you were coerced or defrauded from entering into a loan contract. You may be held liable for non-payment of your obligations once you have defaulted in your payment of your loan. Under our laws on obligations and contracts, such amount become due and demandable in its entirety. The promissory note you executed is proof enough that you willingly entered into such loan agreement. With regard to the post-dated checks that you issued, the moment they bounce for insufficiency of funds, then you may be held liable under BP 22 or the bouncing checks law. With regard to your question on whether you can question the validity of the interest rates on top of the principal amount you loaned, remember that if the parties have agreed on the amount of interest payable on the loan, that agreement is binding between such parties. In the absence of such agreement, the interest due is 6% per year. Regarding your third question, our POEA rules state that aside from New Zealand, countries that prohibit the collection of placement fees include the United States, Canada, United Kingdom, Ireland, and the Netherlands. In Section 3, Rule 5, Part 2 of POEA rules governing the recruitment of land-based overseas workers, as placement fee, it must be in an amount equivalent to 1 month's salary, exclusive of documentation costs, except where the prevailing system where the worker is to be deployed, either by law or practice, does not allow charging or collection of placement and recruitment fee. As to your last question, we do not see how a lending company based in the Philippines have you deported when the case that they can file against you is only one for collection of sum of money. Should they not be able to collect from you, they can very well attach any of your property by way of an action for replevin in order to satisfy the amount you owe them. The following are the grounds for deportation in Canada. First, existence of a criminal record for which a pardon has not been granted. Direct or indirect misrepresentation of facts or providing false information leading to an error in the administration of the Immigration and Refugee Protection Act. Marriage or divorce for convenience, and fraudulent use of immigration documents. Be reminded that our opinion is based solely on the information you provided us, and it may change depending on any additional information. You're free to consult a lawyer of your choice regarding your legal concerns. Email us at ptv4newscenter@gmail.com. Attorney Jimeno Atienza for the Rule of Law.